Everyone is still talking about the new 100,000 H-1B dollar fee, but some people are also saying that the doctors and researchers are exempt from it. Is it true or just an online buzz? Let's find out. Last time, when Attorney Michelle Canero joined us, we couldn't cover it all. So in episode 2, we are back with Attorney Michelle Canero, founding partner at Canero Faudul Rais Law, to unpack what's really happening with H-1B alternatives, the new gold card, and what these changes mean for skilled professionals and employers alike. Well, like I said, we are going to delve into a lot of details today because we couldn't cover everything in our last episode. So without any further ado, let me welcome Michelle Canero to Immigration Talk Show. Hi, Michelle. Welcome back to Immigration Talk Show.
Can you hear me now?
I can hear you now.
Thank you for having me back.
It's a pleasure having you back. Thank you for being here. And guys, before I start the show, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Okay, so after this important disclaimer, welcome back everyone to Immigration Talk Show. We have Attorney Michelle Canero with us today, and we are going to talk about the H-1B $100,000 fee and also gold card and EB updates. And with that, we are live on Facebook, Twitter, YouTube, LinkedIn, and the handle is at Immigration Talk Show. So don't forget to subscribe to us. And if you have any questions that you would like to ask from the attorney, you can put your questions in the chat section. I think Sid Mohan already has joined us and he has already posted 2 questions. So please continue doing that. And if you would like to directly speak with Michelle, the number is there on your screen. You can give us a call on the number 425-436-6335. And don't forget to put the access code, which is 988888. Okay, after this introduction and everything, Michelle, welcome back once again. And so before we begin, I mean, we spoke a lot about in our last episode, but like I said in the beginning, that people are also saying that doctors and the researchers are exempt from this H-1B $100,000 fee. But some people are also saying that it's just a social media buzz. What do you have to say about this?
Well, so the $100,000 fee has a national interest exception, right? There is an email that DHS has published for attorneys to use where you can write an email to inquire whether or not your particular candidate qualifies under this exception. It's going to be a very high standard. So I think there is an argument to be made that rural healthcare workers and the like are national interest. But there's not a blanket exception for these individuals. Now, the other thing that's important to note, and this may be where part of this is coming from, is that people that are in the United States and are filing a change of status to H-1B are not going to be subject to the $100,000 fine, right? So it only applies to people that are getting their visa at a consulate. And that's because the authority under which the administration is imposing this fee is similar to the bans, right? And that's a section of the INA that allows the executive to control the entry of immigrants into the United States and set parameters on that entry. So he has the authority to impose this fee on people coming into the United States, but not on people that are already here. So if you're, example, a medical student in the United States, or you're on a J1 and you want to do an H-1B, then you can do it as a change of status in the United States without paying the $100,000. But there isn't a blanket exception for CAP exempt organizations or for medical professionals. It's if you're in the US and you do it as a change of status, there's no fee. And also there's a national interest exception. But you need to make the argument, and that's up to DHS whether or not they think you qualify.
Okay. And some few days back, I think, when there was this press conference happening, I think President Trump was asked about the H-1B visa. And what he said was that, America, they need H-1B immigrants. They need immigrants to work on H-1Bs, and they need, because those are the talented ones that America needs. So after when this statement came out, people started thinking that there might be, because now he has started speaking in favor of the H-1B visa and H-1B applicants. So maybe there can be some relaxation, maybe regarding the fee or regarding the visa. So, do you also hear, maybe as an immigration attorney, I would like to know your viewpoint. Do you think there is some buzz around this, or people are just thinking that there could be something to it?
So, I think the administration, this president says a lot of things, but we have to go based on actions. He
Mhm.
imposed $100,000 fee per H-1B applicant. It is not a company fee. It is a per applicant fee. If there isn't something, that better portrays his distrust of the H-1B system, or his intention to reduce the influx of H-1B workers, it's that. Now, it targets low wage workers, right? There are some H-1B workers that are getting paid $500,000, $750,000 a year for these tech companies. $100,000 is just part of the comp, and these companies are happy to pay it. So for the high level workers, it works. For that means for the Googles and the Metas and the Teslas who are hiring engineers at $300,000 to $500,000 a year, they're happy to pay that fee if it guarantees they get that worker. And I think that's why the tech companies aren't vehemently opposed to this fee, right? Because it essentially means that instead of having a lottery where they have a 1 in 5 chance of getting their preferred worker in, they basically have a monopoly on H-1Bs so long as they're willing to pay that $100,000 fine. So I think that fee is the administration is going to fight to keep it. Their position is going to be that it keeps more people, low wage workers, out of the United States. The people that are in the country will be able to extend their H's, and people who come here to study or on another visa will be able to do H's. And I think that that's a benefit to our students, because one of the problems has been that when people come here to study, the path normally is an H-1B to continue working after they graduate. And for the last decade, it's been almost impossible for those students to get H-1Bs because of the high demand or the high volume of applications from foreign workers that are outside the country. So now basically this will allow and reward students in the United States with a more preferential treatment, as well as high salaried workers. And I think that aligns with what Stephen Miller's mission is, which is to overall reduce immigration. So basically, H-1B becomes a visa for the people that are already here, not a visa to bring more people to the country.
Wow. Okay. Okay. Michelle, also while reading about this $100,000 fee and while talking about it, also, it feels like you pay the fee and you're going to get the visa. But like being an immigration attorney yourself, you know that the devil is in the details, right? So, is there
Right.
something more to it than what meets the eye, or
No,
it's
so the way
simply?
it's going to work is people are going to register in the lottery, they'll get selected, and they'll be able to apply for the H, but they'll only get it if they're willing to pay that 100,000. So anybody that's you can register, you might get selected, but they're never going to issue you the visa if you're not willing to pay the 100,000. So
Okay.
it's not that you pay the 100,000 to get the visa. It's just that it weeds out the people that are unable or unwilling to pay the fee.
Okay. So there's
So,
definitely more
so
to
it
it then.
will. So I think that the idea is that there will be less people in the lottery because there'll be less people that would normally be using the H-1B lottery system from outside the United States, but that are unable or unwilling to do the $100,000 fee. For example, is it what is the big? Is it Tata? There's a couple of big Indian staffing companies in the U.S. They've announced that they're not going to be doing H-1Bs anymore. they'll have their workers in California or their workers that are here in the United States. I see someone's putting Infosys and Cognizant. Yeah, I mean, some of these companies are just saying, okay, we're not going to participate in the H-1B program anymore. We'll do the Ls. They have offices in other countries, put people on a one-year payroll abroad, and then transfer them over in an L. And those may be better options for them, that kind of worker, than the H-1B system.
Okay, so basically those companies might just start moving those jobs to offshore instead of hiring those in the US.
Well, those companies have always primarily been foreign workers, right? So these tech companies that offer staffing services, meaning they're a staffing company. Their employees that they bring primarily from India are the workforce that they supply the American tech companies with. And so these staffing companies will do a lot of H-1Bs to bring over workers that then they essentially lease out on subcontract agreements to the tech companies that maybe didn't want to secure or couldn't secure an employee on a W-2. So what's going to happen is these companies are just saying, okay, we're not going to use the H-1Bs anymore because it doesn't make business. The business model doesn't make sense if they have to pay $100,000 per person. Their profit margin is based on being able to market that worker at a higher rate than they pay them and keep the profit margin. So if they have to go out of pocket $100,000, it doesn't make sense. So what's going to happen is those companies aren't going to use the H, which means that there'll be less people in the lottery, which may make it more likely for people who can qualify for the lottery or are willing to pay the $100,000 to get selected.
Okay, okay. And you were talking about, you said that now people are also opting for L1 visas instead of the H1B. So between L1, O1, or J1, which one visa is the most reliable for somebody who can't get H1B right now?
Well, each one is its own sort of ecosystem, right? The L1, it works for people that are the employee of a company abroad that has a US affiliate. So the way an L1 works is you work for 1 year in a managerial, executive, or specialty occupation for a company abroad. And after documenting 1 year of full-time employment, you can be transferred in a managerial, executive, or specialty knowledge role to the US to work for the US subsidiary. And then you could do that for a maximum of 7 years. So that's the L. The O1, also employer sponsored. So you need a US company to sponsor you or an agent, but that's more talent based, right? So in an O1, you have to show that you are recognized in your field. And depending what your field is, whether it's in business or the arts, there are different criteria to show that you have that recognition, whether it's awards or press, whether you've served as a panelist on some sort of jury related to your field, whether you earn a very high compensation compared to others in your field. But it's all about showing that you are highly recognized as being in the top percentage of individuals in your field of work. And that's the O. And then the J, that depends. Are you coming as a trainee? Are you coming as an intern? What is your skill set? And based on the reciprocity tables and the skills list, whether or not you're subject to a 2-year residency requirement. So the J has a variety of models, but again, limited time and may require you to go back to your home country for 2 years before you can apply for an H or another type of visa. So I think the idea that, is the administration is trying to reduce the amount of foreign workers that come into the US market to compete with American workers, but they're willing to provide a path forward for people that come to study here. So I think that's why we've seen that there is, the administration just announced that they're going to allow several 100,000 student visas from China. So they're encouraging people to come to the United States, invest in our academic institutions, study and get trained here. And I think part of the H-1 plan is to allow those people with more access to the H-1B programs. I think that's something that the administration said in their campaign. They wanted to make it easier for foreign students that were trained and educated in the United States to work here.
Yeah, yeah. Okay. And with the constant visa changes and everything, I mean, visa policy changes, the rule changes, lately the visa process feels like a moving target, right? So, with the different visas available for the H-1B, I mean, people who want to opt for other visa options instead of the H-1Bs, do you think in the near future the administration can also come up with maybe a lot of policy changes for these other visas as well?
Well, so the problem with visa criteria is it's congressionally regulated, right? So there's legislation to enact a new visa category. You have to pass a law in Congress. And then based on that law, the agency can issue or promulgate rules that interpret the law. You can't, and then you can do some policy, but there isn't a lot you can do in policy and rule promulgation to create access to visas. That would require Congress. And I don't know if you follow the politics of our country very much. Our Congress is not very unified. I think it will be very difficult to pass pro-immigration legislation in the current makeup of our Senate and House of Representatives.
Okay. I mean, we are watching everything, and especially with the government shutdown and everything, so many things are happening. So we
I
are
know.
following. Yeah.
Yeah, I mean, I think we don't have a very we're very divided politically, and that really makes an issue for us to, makes it an issue for us to pass things because you need both sides to agree. And then you need the president to agree. So that's another problem, right? You may be able to get bipartisan support, but they'll never put it to a vote because they know the president won't pass it. That's one of the things that they said about DACA and other legislation, that they think, okay, we can get bipartisan support, but if the president isn't willing to sign off on it, then no one's going to stick their neck out.
Yeah, true. That's true. Well, thank you so much, Michelle, for answering all these questions. I see people, our viewers posting their continuous questions on the chats and the chat. So how about maybe if I give a little bit of rest to my questions and move to the viewers?
Let's do that.
Okay. So, let me take maybe Venkat's question. Let me start with Venkat's question. Let me start from the bottom today. Venkat is here and he says, have there been any recent USCIS policy changes or trends that make EB1 or EB2 gold card approvals more accessible or more challenging for Indian applicants?
Okay, so I have submitted, the gold card request. It's a form, you do it online, and they're supposed to send you information. I've submitted several requests and we have not gotten any feedback. So I don't know. It's kind of like it's going nowhere. I don't know if they're going to publish something, but we have submitted, that we're expressing interest, and I haven't gotten any feedback on several applications I've submitted. So I don't know if there's anybody monitoring that website or if it's actually a real thing. So that's where we are. I do know that the scheme, the schematics of it is, as Lutnick said, they're going to be pulling from EB1 and EB2 numbers, which means that, they're basically taking what's already been passed by Congress and that procedure, and just creating a qualification for EB1 and EB2, saying that $1 million contribution is evidence of a one-time achievement or exceptional ability. And so that would allow you to, by proving that you earned that $1 million, argue that you qualify as a national interest waiver or as an EB1 extraordinary ability. And the forms would be, the same forms we use on an EB1 and EB2. But as of yet, I do not know anybody that's gotten that far in the process.
Okay. Okay. So Venkat, I hope you have got your answer. Thank you for your question. Let me quickly move to Sumit's question. He says, have there been any recent USCIS policy changes or adjudication trends that make EB1 or EB2 gold card approvals more accessible? I think Venkat and Sumit, you guys have posted a similar question. So
I
still
think
has
that's
a couple
the
of
same
questions.
one.
Yeah, yeah. No. So, okay, Sumit has this question. He says, for Indian professionals currently on H-1B, what are the most viable alternatives such as O1, L1 that allow continued employment and career growth without relying on lottery-based renewals?
Well, I mean, I think you said it, right? If you have an H-1B, you can renew your H-1B. That's not a lottery, right? So once you get selected in the H-1B, you no longer need to be participating in the lottery. So it's once you're selected, that's it. You can do your renewals, and you can renew them for up to 6 years, or if you have an approved I-140 or PERM with a backlog priority date, you can continue to extend it under AC-21. So that's the H. The other work visas for Indian nationals would be the O or the L or the J or the F if you have, CPT or OPT. Those are the traditional work visas. Now, there's certain visas for like the World Bank, and there's ambassador visas and that kind of thing, but those are very specific. And then for Indian nationals that maybe have a second nationality that has a treaty with the United States, for example, I have a lot of Indian Canadian clients, they can do an E2 as a Canadian national, which is an investor visa.
Okay. Okay. I also want to talk to you about, this EB1, EB2, NIW versus gold card, which which I'm going to ask you in a bit. But before that, let me take Sid's question. Sid says, H-1B approved in 2023 and renewal in September 2026, planning to have first time stamping in India in March 26. For how long will the stamp be valid? Will it be considered expired once I renew H-1B in September 26?
So they can't stamp your visa beyond your approval date, right? So you're going to get stamped based on the visa reciprocity table for India, no further beyond the end date on your approved I-129. And then once you renew, your H-1B will expire on the date it expires, right? The visa will expire on whatever date it expires. You get a renewal approved if you're in the United States and you did that renewal as a change of status. Even though your visa expired, what controls is your I-94. So your status will be extended. If you leave, you will need to restamp the visa at the consulate before you return to the US. Otherwise, it won't let you in. You need to have a valid H-1B visa when you come back.
Okay. Okay, Sid, I hope you've got your answer. The other question that he wants to get an answer to is, can reference letters from early stage startup CEOs starting volunteering contribution to raise funds and get projects be used to meet O1/EB1 awards criteria? Startup is not employer and has no earnings yet.
I think that's a very case specific question. I would suggest it requires more context to understand what you're trying to accomplish, what's the field in which you're trying to accomplish, and what are the purpose of the letters that you're getting. So my suggestion would be to schedule a consult with an attorney and really assess your case.
Sid, you can also, get in touch with Michelle herself. Here is the link to her website. It is going to direct you to her website. So please click on this link and it is going to direct you to her website, and you will get all her details, contact details over there, and you can directly get in touch with her for a detailed consultation regarding your issue. And one more question that he asks is there any clarity if the employee can pay fee / part of this 100K H-1B fee?
So the employer is the one who has to pay the fee. Similar to other H-1B filing fees, the 100,000 is paid by the employer. Now, we do allow H-1Bs to self-petition, so you can have a U.S. company that you own petition your own H-1B, and in that case, your own company can be the one that pays it.
Okay. Michelle, somewhere I read somewhere that, if your employer is asking you to pay that $100K fee, it is going to be illegal. So you might directly have to report it to someone. So, is there any truth to it? Is it illegal if the employer asks the employee to pay that fee?
The employer cannot ask the employee to pay that fee. The employer has to pay it, like all H-1B fees. The difference is that if you are the business owner of the employer, the company that you own can pay the 100,000, and the company that you own can be your H-1B petitioner, because now we allow for companies that are owned and controlled by the H-1B applicant to submit H-1B petitions. So it's not you paying it, it's the petitioning company. So it's always the petitioning company that pays it.
Right. And if your employer, if the employer asks you to pay the fee, it will be considered fraud, right?
Right. It's the same way as the employer asking you to pay the H-1B filing fees and deducting it from your salary. They can't do that.
Okay. Thank you for clearing that up, Michelle. Let me move to the EB1, EB2 NIW versus gold card questions. So I want to start with the big one. So if someone has already an approved EB2 NIW, should they be worried that this new gold card policy could cancel or override it?
So my concern is, again, I haven't seen any of these cases being processed. We have made several requests, submitted several inquiries. None of them have gotten a response back. So I don't know what's going on with that program. But the idea is that they are taking the numbers from EB1 and EB2, which means that we could see a retrogression in EB1 and EB2 categories based on the carve out of 80,000 visas for the gold card.
Okay. And also, if EB1 or EB2 categories get suspended or replaced, do people stuck in the backlog just lose their place in line?
No, you don't lose your place in line. You always have your priority date. It's just a question of how long it takes for your priority date to become current. Could take longer.
Oh, okay. And we also keep hearing that $1 million gold card guarantees a faster green card. Is that actually true or just a political marketing?
As I said, I've had multiple clients that have submitted inquiries for the gold card, and we have not gotten a single response back. So we filled out the web form with the information, and there's been no feedback.
Okay.
So it doesn't seem like, I don't know of anyone that has actually received a response from that inquiry.
Okay. And if someone donates $1 million, gets the gold card, and then completely checks out, does that still count as being in the national interest?
I have no idea. Not a single one of these has been processed yet.
Okay.
Like, we really don't know, right? We've set out, the administration has shared what it plans to do, but it hasn't done any of it. So how do we know? I don't even know how they're going to take the million, where it's going to be paid. Is it going to be cash or check or credit card? How are they going to do the due diligence to make sure that that's not, ill-gotten gains? Who is it going to be paid to? When in the process is that $1 million going to be paid? Nobody knows.
Yeah. Okay. And also, some people are calling this gold card just EB5 in disguise. So do you see it as a rebrand or totally a different concept?
Totally different concept. EB5, you are investing in a program. that program has a potential for return on investment, and you are entitled to claim a request of a refund. An EB5 is a conditional residency. They don't give you an immediate green card. You have to get a conditional residency, prove that the funding and the program worked successfully, and then request a removal of conditions. That removal of conditions is not guaranteed. In the last few years, we've seen a lot of I-829s denied, and people who had their conditional residency end up in removal proceedings. So the idea of the gold card is that, like an EB1 or an EB2, you're getting a straight permanent residency, and that's it. There's no conditions, there's no investment, but you're gifting that money to the government. You're not getting it back. Versus an EB5, you're investing it in a project, and there is it's investment. There's a potential for return.
Right. Okay. And I also see Michelle Fawad, one of our viewers, Fawad, is also here. And he says, I've been on H-1B for a few years now, but my employer isn't initiating the green card process. What are my options to self-petition under EB1A or NIW? And how do I know if I qualify?
Well, you can self-petition under EB1 based on proving that you meet at least 3 of the criteria and that you have risen to the top of your field, right? So there's a totality of the circumstances test in addition to establishing the three criteria. You can go on ChatGPT and look up what those criteria are and how to establish it, and then meet with an attorney once you've identified some criteria that you think you can qualify for, and have them evaluate the quality of the evidence in your case and guide you as to how you may be able to improve it. I will tell you that even somebody who is at their top of their field objectively, meaning not just I'm an engineer and I get paid well and I have some recognition and some school awards. Like, no, you have to be one of the top 10% engineers in your specific area, in your country or nationally, right? And then the EB2 National Interest Waiver requires an advanced degree or its equivalent. And you have to prove that the work you're doing in the United States or will be doing in the United States is of substantial merit and national importance. And that requires you to prove how you plan to work in the United States. It should be as an independent contractor or a business owner, because when you're an employee of a company, then you don't meet the balancing test of why a labor certification waiver is merited, right? So if you're just an employee, although I have heard of people getting an EB2 approved, primarily you need to prove that the employer is unwilling or unable to do a labor cert, and that's why you're doing it, because there is this balancing test. You have to show why a labor certification isn't feasible, and for anybody who's employed by a company, that's very hard to prove. And then you have to, show what the impact of your work is going to be on a national scale. So I'd say that on EB1 and EB2, even somebody who meets those criteria has an argument for national interest, or meets the criteria of an EB1 and can argue that they are, in the totality of the circumstances, risen to the top of their field, they still only have a 50 to 60% chance of success on average. That's about the approval rate of these cases. So I think it's worth trying, but you need to work with a very experienced attorney. I would not go with the billboard attorneys. I would not go with the cheapest attorney. I also wouldn't go with the most expensive attorneys. There are some of these companies that promote themselves a lot on the internet, and, their quality of work or their statistics of approval haven't been the best. So you really need to do your due diligence and make sure that you get personal references, people that have worked with that attorney successfully, probably before you hire them. Because this is, it's a bit of a predatory business, this visa stuff. So.
Yeah, I'm sure. And, but Michelle, being an immigration attorney yourself, would you have would you like to suggest some strategies? How can these people identify who's actually reliable and who is just promoting themselves and just, marketing themselves as a good attorney, but it's not actually is?
So the first thing I think you need to do is figure out what's the attorney that's going to be handling your case, right? At a big company, you're not going to have a particular attorney assigned to your case. You want to make sure you're dealing with an attorney. Even if there's a paralegal or an associate working on your case, you want to make sure that there is an attorney that's developing the initial strategy for your case. The second thing you want to do is look up that attorney's bar license. Don't ever work with somebody that is not a licensed attorney in the United States, okay? So you need somebody who is a member of the bar that studied at a U.S. university and has a U.S. law degree and is licensed to practice as an attorney. Okay, that's primordial, because if something goes wrong, if they are not a licensed attorney, you don't have a defense. And this has happened where I've seen people use a paralegal. The paralegal maybe put wrong information in their application. Then when I go to file, they claim that my client committed fraud because they put false information, even if it wasn't significant, wrong dates, wrong employment history, incorrect information about marital status. They claim that my client committed fraud or misrepresentation, and a fraud finding is a bar to any future applications. So it's a big hurdle. And if the client didn't use a lawyer, I cannot argue that it was a mistake they weren't responsible for, because if you just had a form preparer, you signed it yourself, they're saying, well, no, you can't argue that you had misinformation from an attorney or you were poorly guided, because you didn't have an attorney. So you always want to have an attorney, because you can, if there's a mistake made, you can say, well, I relied on the advice of counsel, or my attorney advised that. People make mistakes, but you don't want it to be your mistake, because that's not forgivable. Yeah. The other thing is do your research on fees, right? Any attorney that's going to actually do a good job is going to charge a reasonable fee for their work. An EB1 or an EB2 case should take 20 hours of time. Mm-hmm. That's how much time you absolutely have to have in emails, meetings, writing, package assembly, evidence assembly. So if you're working with somebody that's charging you less than $10,000 for a process, you kind of want to understand what their hourly rate is, right? So ask them what their hourly rate is, multiply that by 20, and that's going to give you an idea of how much time they're going to be spending. If somebody says their hourly rate is $300, but they want to charge you $2,000 for an EB2, then maybe that person's only going to spend 5 or 6 hours on your case. Does that make sense? Not really. Mm-hmm. You want someone who's going to spend more time, right? The hourly rate of your attorney is also going to vary based on their qualifications. A recent graduate associate may charge $150 an hour. An experienced attorney is going to charge upwards of $500 an hour. Well, the hour of an experienced attorney is much more valuable because they have a lot more knowledge and can accomplish a lot more in 1 hour than an associate straight out of law school that doesn't know anything and is prone to make mistakes and is going to take a lot longer to research and figure out your case. So again, the quality of representation is going to be reflected in the hourly rate. And the amount of time that the attorney is going to spend on your case is going to be reflected in their flat rate. So all cheap means is less time and less experience.
Wow. Okay, that's beautifully explained. Thank you so much for such detailed and beautiful explanation on how to find out the correct, the correct attorney for you. I think we are going to create a short video on this question, with this question, and we are going to put it up, a completely different video, how to find out a good attorney for yourself. Thank you so much, Michelle, for that great answer.
You're welcome.
So, I am continuously able to hear the email notifications popping. I'm sure a lot of your clients are waiting to hear from you. So before I let you go, one last question that I would like to ask from you, that, about this gold card, some people online say this gold card is just, election year politics. So do you think it's more headline than policy, or could it really reshape immigration?
I mean, I think this administration, this president in particular, has not shied away from the idea that if you want to get in his good graces, you need to pay him. So this lines up with the whole pay for play attitude, which is you want the privilege of being in this country, pay me $1 million. I don't know if he can legally do that. So that remains to be seen. I don't think he can legally carve out 80,000 visas from the existing processes for his preferred category he's trying to make up. So I don't know. This is one of the many things that we're going to just have to see how it plays out. But this is a president and an administration that acts and then thinks it through, right? So we saw this with visa bans. We've seen this with a lot of policies. They sort of say $100,000, and then they figure out whether or not they can legally do it, which is why we kept seeing, okay, no, it doesn't apply to anyone that currently has an H-1B. Actually, no, it can't apply to anyone that, you know, is in the United States doing a change of status because we don't have the authority. No, it doesn't apply to these people. So like, as they realize the legal precariousness of their strategy or policy, they're adapting. But again, it's a very like, I guess it's Elon Musk says, right? In tech, you move fast and you break things and then you fix them in the aftermath. That's how a lot of these policies are coming out. And I don't know, legislation doesn't work that way. Legislation requires, you know, because of the APA, the Administrative Procedures Act, you know, it's got to be passed by Congress, and then it's got to go through, rules have to go through public comment and implementation. You just can't do things from one day to the next. The bureaucracy of our country doesn't allow it. So we're just going to have to see how all of this plays out.
Okay. Thank you so much, Michelle, again for being here. It was lovely having you. You had some great answers for our viewers. So thank you again for being here. I'm hoping to see you very soon with maybe another topic whenever you are available. I know you're very busy, so we'll give you some time to be back. And, you know, I think next week, we are going to have Thanksgiving. So I'm wishing you happy Thanksgiving in advance.
Thank you.
And thank you so much again for being on Immigration Talk Show.
I truly enjoy talking with you, and I love the questions. So I look forward to our next chat.
Thank you so much. Guys, if you want to get in touch with Attorney Michelle Canero, here is the link. Please click on this link and you will be directed to her website. There you can find all her contact details, and you can email her and also give her a call if you're looking to find an attorney for yourself for a detailed consultation regarding your immigration or your visa chaos. And thank you so much for being here, posting your amazing questions. We really enjoyed taking them. I'm going to see you all very soon, but until I see you again, make sure to like this video, share this video with anyone who you think can benefit from this information. And also don't forget to subscribe to Immigration Talk Show. I am Rajni Bharara, your host. Bye and take care.